Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to protect yourself, your family, and your business. We provide information and resources that might help you decide whether or not you might want to handle some issues yourself. Perhaps we'll even help you determine whether or not you can do that very well yourself. If you do decide to seek additional outside counsel, you'll be better prepared, and as a result, so will the counsel that you decide to select. Obviously, our goal is to have you save time, save money, and achieve a better outcome. We want to welcome and thank the Bazar law firm, who continue to provide us their insights, their information on the various issues that we tackle. Attorneys Jacqueline Grasso and David Bazar compose the team, and with us today is David Bazar. So, not surprisingly, we need to talk about Deflategate. So our topic today is the legal process as it pertains to Deflategate, but also how it reflects some important issues that are labor and arbitration, rules, policies, fairness. What's fair? Well, as a way of context here, coincidentally or not, related to the NFL research that I uncovered while I was looking at this, I want to read something briefly that says, the posturing involving Saints Bountygate, this was a little bit of history, makes little real sense, but settlement of the lawsuit is very difficult due to issues of ego, power, opposite viewpoints, and lawyering. Tough to figure out what the NFL's goals were, other than to demonstrate that they have power over the NFL's Players Association. So now we have Deflategate that we're going to talk about. Different day, different team, similar story, and as of this taping, actually just a couple of hours ago, Judge Berman decided that he was going to vacate the Brady 4-game suspension, and minutes ago, Roger Goodell said, thank you very much, Judge Berman, and we're about to appeal. But we have so much to discuss relative to this. So, David, legal processes aren't very interesting from a PR standpoint, but they certainly have problems with it. But they're important whether we're talking about criminal things that might be going on, or the league's discipline and all of those legal processes. They've been harming the league, lives, jobs, reputation. Goodell talked about wanting to get it right. Did he really get it right when it comes to all of this fairness? What's fair? What's legal?
From a legal perspective, this case is very, very interesting, and it does reflect on labor law in a number of different areas, and how the federal courts work, and how the federal arbitration laws work. So we can just dig in on all of those things, because there is a lot to it.
So without going back to the beginning of time, as it seems, this has been going on 7 months or something, when Judge Berman was asked to handle the issue, there was some dispute or discussion about how wide does this get to go? When there is something that's brought up to this judge, could it just and only be about that 4-game suspension, or how about the whole process of the arbitration, and should it ever been undermined? Who gets to do what and tackle what, David?
So we're talking about labor law and unions and management in this situation, and all of that is usually, and in this case in particular, bound by the collective bargaining agreement that the union and the company or the management association have entered into. So if you have a Teamsters issue where there's an issue with an employee, you look at the collective bargaining agreement to determine what the process is and how that works. Same thing for the NFL and the NFLPA. So they started this whole investigation, and I'd love to get into all of the issues regarding what they did and how they did it, and whether it was a prosecution or an investigation, whether it was, set up and they were trying to entrap them into some of these things. But from the legal aspect of it, you start with the collective bargaining agreement. So what happens at the beginning is the NFL sends out notice that they're going to investigate the deflated footballs in the AFC Championship game. So everyone's put on notice, and the process begins. And the process began with the NFL, theoretically, hiring an independent investigator to do the investigation. So at that point in time, Tom Brady's notified that he's being investigated, and he's told what he's being investigated for, theoretically, and the Patriots are investigated. And so then the issues start coming afterwards once the Wells report is issued. And so what the Wells report says is that the Patriots and the organization Robert Kraft, Bill Belichick, all of the executives of the organization had nothing to do with the footballs being deflated. But Tom Brady, they said, was generally aware that the footballs may have been deflated, that somebody else may have done something to deflate the footballs. Yes. Not that he instructed them to do that, not that he was involved in a scheme, as the commissioner later tried to say, but that he was generally aware that the footballs may have been deflated. And then Troy Vincent, I think it was, sends a letter to him saying, based on the competitive integrity of the game and your non-cooperation, because they said he didn't turn over his cell phone, we are suspending you for 4 games. They also punished the Patriots and Robert Kraft and Bill Belichick, the team, by taking away draft picks and fining them $1 million. And that's based on a report that said they didn't do anything wrong.
So if you're the lawyer, and obviously I bet you wish you were, considering it's meant something like $10 million, David.
I would have done it for one.
I bet you would have, and you would have done a swell job, I'm certain. But when they talk about the things that are listed in the agreement, people are talking now whether or not that was actually fair or unfair. Okay, we can go there or not. Tom Brady, for what you could have been accused of being aware of, you might have $8,000, and that's in some of a fine. That's somewhere listed. So that somehow has spiraled so far out of control just at that point. Never mind this Wells report that you refer to, when there's a general awareness. They had no real evidence that said that anything actually did happen. They also listed in this voluminous report, for which that firm had acquired so much money, they said at the time that they didn't want that cell phone, that it wasn't necessary, and made some comment to the effect, we don't even have time to look at it for that much money. They probably should have had time, but that's another issue. If you say you don't need it, and Tom Brady gets rid of it, as he does frequently, I guess he has enough sprints and the rest who want to have him have a phone, he's used to getting rid of it, ditching it, and I guess because he's a celebrity, why wouldn't you want to get rid of all of the data?
Right.
The phone company could have looked it up. How did this so spiral out of control from a legal standpoint?
Right. And so we can get back into all of that, what may have happened, why it happened, and who's at fault for it happening. But we're trying to keep this to the legal issues.
Just the legal.
Just the legal issues. So, and what you bring up is actually, as it turns out, probably going to be very important, and I haven't had a chance to go through in any detail the decision that, as you know, just came out just before we got here.
40 pages worth, apparently.
Right. But what you brought up is going to probably be one of the things that the judge looks at and latches onto in vacating the decision. And that is, he was told at the time of the Wells investigation, he being Tom Brady, that, well, we don't necessarily need everything, and Wells testified in the arbitration, and we should just talk about the legal process as this unfolded, but just to answer your question, he was told, Wells testified in the arbitration, I never told Tom Brady there would be any penalty for his not turning over the phone. And that goes to, what is Tom Brady on notice of that might be something that results in a suspension? And we'll get into that as we try to go to what the decision probably looks like. But before we get there, let's talk a little bit about the process. So Wells does their report. Within the Wells report, it's the investigation of all of the people who may or may not have been involved, in players and executives, and they hired an independent or outside scientific company to do an evaluation of the data from the deflated balls. And my recollection of that was that they said, well, we really can't tell you with any certainty that anything happened because we don't have enough information to know what the starting point of the inflation of the balls was, or what gauges were used to measure the balls initially and then at halftime. So even the scientific data that the NFL paid for doesn't necessarily even support a conclusion that anything was done to the balls. Be that as it may, what happens is Wells issues his report. Fay Vincent, issues the letter to Tom Brady and to the Patriots with their penalties, and then they have the right to appeal. As you know, Robert Kraft didn't, and I understand it's a business decision. He didn't want to put himself at odds with the rest of the owners, but Tom Brady did appeal, and so the appeal then goes to Roger Goodell, and he decides who's going to hear it. So what happens from there is the collective bargaining agreement kicks into place, and Goodell says, I'm going to act as the arbitrator.
Yes, how nice. So when they say, gee, we think you should settle, that would be so much better to let the collective bargaining agreement, the CBA, work versus going through all this expensive litigation. And yet, someone would also say that collective bargaining agreement, you know, hindsight here, that wasn't fair to begin with. But even if it wasn't an issue about whether or not it was fair, he still overstepped his bounds within the CBA agreement. This is what you're entitled to do. This is how far you exceeded that. There was never an issue about 4-game suspension, how much money that Brady would lose, and you can argue whether or not that was a terrible loss or not, but that's not the issue. Plus that first-round draft pick, which I guess is worth its weight in gold. But all of these things then suddenly bring into question how does the jury, judge, and executioner, which Goodell writes into this CBA, how does this give him the right to go back and still exceed and increase the fines and the penalties so that it brings this all into another legal realm that it should not have?
Well, there are two different issues. So the first issue is it appropriate for the commissioner to act as the arbitrator, really to review his own decision, even though he says it's not his decision necessarily? And the answer is yes. He has absolutely every right under the agreement to do that. And really, that wouldn't be something that a player could challenge because the players' union agreed to that.
Yes.
What it doesn't address, and a lot of people who are arguing that, well, Article 46, I think it was called, under the collective bargaining agreement allows him to do this, therefore he can decide whatever he wants to do, and once he decides it, that's it, you have no recourse. Well, that's not true, because all that allows the commissioner to do is to say, I'm going to appoint myself as the arbitrator. Why he would ever want to do that, I don't know, but he chose to do that in this case.
And he has the right to do this.
He has the absolute right to do that. Rock solid foundation, and if he did then serve as the arbitrator appropriately and did all the things he's supposed to do as an arbitrator, they would never lose this case. But he didn't. And so there are a lot of problems with the arbitration. And so the ones that were raised and that I listened to them make arguments are, and so I'm assuming that the judge may have latched on to some of these in his decision, are, number one, he said, he being the NFLPA, Kessler, that Tom Brady wanted to call Jeff Pash, the general counsel of the NFL, as a witness. And the importance of that is the NFL had stated in a press release that Pash is the co-investigator with Wells, and Pash edited the report before it came out. So they wanted to be able to cross-examine him. And the arbitrator, Commissioner Goodell, said, no, that'll be cumulative. And in the arguments, the judge said, how do you know what he says is going to be cumulative until you hear him testify? So he was latching on that that is not correct. And so what you have to find on an appeal to the federal court of an arbitration is, if the challenge was simply Goodell shouldn't be the arbitrator, you lose. If the decision or the appeal is he really misread the facts and his finding of facts are all wrong, you lose. But if it's an issue of whether or not there's fundamental fairness and did Tom Brady have due process in going through this procedure, then you have a case. And that was something that I heard the judge latch onto. Yes. Why didn't you let them call Pash? You really needed to let them call Pash. The other thing that I heard some discussion about was that they weren't supplied with all of the same records that the NFL had. And again, here's another little twist. The lawyers for the NFL in the arbitration was the same law firm that Wells works for, the independent arbitrator. That's going to raise some flags with the judge, but again, in and of itself, probably not enough to make him vacate the suspension. But if, as a result of being that same law firm, the lawyers for the NFL have access to materials that the defendant, Tom Brady in this case, isn't given, so that he can review those for preparation for the hearing and testimony at the arbitration. The judge might again find that that violates due process and fundamental fairness. And I think it's a good argument, if that's what the judge latches onto, that, as you say, if Goodell appeals, will be difficult to overturn on appeal.
So he is. And then there's another minor issue, I guess, which was, I guess Brady had been given personal counsel, and he was told to do certain things. So by the time Judge Berman is, or not to say certain things, by the time Judge Berman is discussing this, he said you should be able to settle, negotiate and settle. Well, if one of those things is, Tom, just admit that you're guilty, he said he was never going to do that. If you're the lawyer for Tom Brady and you say if you're not, you really shouldn't do that, maybe you could argue later, maybe he should have, maybe he shouldn't. But if he said, I told my dad I didn't do it, I told my lawyer, I told my teammates, I told Mr. Kraft I didn't do it, I can't go back on that now. By the time Judge Berman says to them, gee, do you think you might have handled this differently? Well, I suppose you could argue that, but why would that allow Berman to say, I think that on that reason, that also is a reason to overturn or to nullify that suspension? He might have been ill-advised by that personal lawyer. Does that count?
Yeah, no, I don't think those are issues that would weigh into how Berman would decide this case. But you do raise an interesting issue as to what happens next in our little journey down this legal process. So the commissioner, as arbitrator, issues his decision, and he actually goes a little farther than the Wells report in saying that not only was he generally aware, but he was involved in a scheme. However, in his findings, what the commissioner did was he accepted and adopted the findings of the Wells Commission, a Wells report, which basically said that he was generally aware, and that's the basis for our penalty. And then he issues the 4-game suspension for whatever reasons. And again, the judge asked, well, what's the breakdown? Is it 1 game for not cooperating, 3 games for knowing that somebody may have deflated a ball? Or how do you do that? And they said, well, the collective bargaining agreement doesn't require us to break it down. Well, the judge wanted it broken down because he wants to know whether or not, and this goes back to the notice, does Tom Brady have notice of what the penalty might be before anything is done? So that's not given. So that, again... That was one of the things he mentioned. Exactly. All right, and so we'll talk about that when we get to the decision. But what you did raise was the whole interesting, now we've appealed this from the arbitrator who's made the final ruling under the collective bargaining agreement to the federal court. And 2 interesting legal things happened there. The NFL, which knew when they were going to issue its decision, when the arbitrator / Commissioner Goodell was going to release it, probably seconds later had somebody in the New York federal court ready to file a motion or a petition to approve the arbitration, which can be done, but it's not always done. It's not usually done. Good to know. But they did that to try to direct any appeals that the Players Association might have taken to that court, the Southern District of New York, rather than to Minnesota, where the federal court judge in Minnesota has been hammering the NFL left and right. So they were just trying to take a little home court advantage and be a little strategic in getting the case to New York. And lo and behold, that's exactly what happened, and the judge in Minnesota, who wasn't the judge that they were afraid of, but a different judge, said, wait, they filed first, it's already pending in New York, maybe by hours, but we're going to send the whole thing there to be consolidated, and that's what happened. So from a legal perspective, it was very interesting to watch the NFL and their legal team try to scheme all the way through this to try to get as many advantages as they could. But interesting. What they didn't do was handle the case procedurally correct from the beginning. If they had done this correctly, it doesn't matter where this case went, because the Article 46 of the collective bargaining agreement is very strong and gives them a great deal of latitude. And if they had handled it correctly, it wouldn't matter if the case was heard in the Federal District Court of Alaska. I just make that up. I understand that started when the players didn't want to have 2 practices a day, and so the trade-off was to let Goodell be
chief cook, bottle washer, and executioner. So when they're in this place of there being what they might call a bad decision on Goodell's part, what are the chances that the courts are going to overturn this as they, I mean, do they, once it's in arbitration, is it likely that someone is going to upend that? Does that usually happen?
So the standard for a federal court judge to confirm or vacate an arbitration award is a great deal of deference given to the arbitrator. So unless the arbitrator has done something, in this case, and in most cases where they're going to look at a problem that violates fundamental fairness, due process, or other constitutional rights of the employee in this case, but something that really affects the process. And again, I told you, they don't even look at the findings of fact of the decisions because they're not supposed to. But I think that they can and do in some instances. So just by way of example, my thinking in this case was when folks were arguing, Article 46 controls this. The commissioner can do whatever he wants. The commissioner has complete power. It's all up to the commissioner. He's the czar. He does whatever he wants to do. I was thinking, well, how could the commissioner take, for example, a generally aware standard that something may or may not have been done, and then give a penalty, in this instance of 4 games? What if he said,
severe, I'm
going to suspend him for a year, 2 years, life? Well, is it the penalty that they're looking at as part of it or not? Because if you look at it and you say 4 games has never been given, the penalty is important, because if he had given 1 game, this probably wouldn't have gotten here, because you could argue that maybe there's some precedent or standard for that. And again, going back to the third prong of the appeal, and I know there were more than this, but the third prong that we talked about at the beginning is what notice did he have that he would be subject to a penalty? And you talked about that a little bit at one point in time when you said fine. Because,
$8,000.
Right, because there's 2 or 3 different areas that they could have gone after Tom Brady in this. And I use the word go after because that's what they did.
That's what they did.
So they could have gone after him with the notice that the players have that an equipment violation will result or can result in a fine. There's nothing in there about a suspension. What they had given him notice of was this competitive integrity of the game standard. And that standard has been sent to the executives. It was never sent to the players. So Tom Brady's argument is, and was, I didn't know that applied to me. I had no notice of that. And you talked about the two-a-days, and you talked about Bountygate. And a lot of the defenses to those cases was, I had no notice what the penalty would be for violating this. In the NFL, the management has to give me some advance notice before you can punish me. And so Tom Brady's argument is that I wasn't on notice that this would be a violation of that. And so then the judge tried, not the judge, the arbitrator, Commissioner Goodell, tried to equate it to something that is already on the books, which was steroid use, right? So with steroid use, that is spelled out. With now domestic abuse and those types of things, it's spelled out. They have notice. But they couldn't apply it retroactively to the players who it was based on and why this process was put in place, because they didn't have advance notice. So that was a big issue for the judge in the arguments, and I think that's probably one of the things that he put his hat on in making this decision.
So let's extrapolate from that just for a moment. Suppose you are with a collective bargaining agreement and you're talking about general labor issues. If someone doesn't think that the bargaining agreement is fair, that's the employee, can the employee challenge the king? Isn't it a little difficult to do that? Do they have to go and scrutinize does their union representative have to, and the lawyer have to scrutinize every single issue again and go back to say, is this really a fair punishment for whatever it might be? How does that happen, David?
As the employee, you're not going to be able to go back and say, this aspect of the collective bargaining agreement is unfair, or that aspect of it is unfair. It really comes down to how the process is put in place based on the collective bargaining agreement. And what the NFL didn't do in this case is they didn't apply it fairly. They didn't allow due process to the accused, in this case Tom Brady, and therefore it's overturned. But another interesting aspect of this whole thing was how the federal court judge tried to get them, I wanted to say impose, but try to force the sides, encourage to come to a settlement. And so there was mediation involved in the process of that. I found it interesting because I've been involved in federal courts with mediation on several cases in the past. And it was interesting to me, as I understand it, and I don't know what happened behind closed doors, but that the judge was very much involved in the mediation of this case. And whether or not his hearings on the merits of the case in courts was part of that process, I'm not sure. But many times the federal court judge will send the case to a magistrate judge who helps the federal court judge with his cases to have the parties go through mediation, or to a federal mediator. In this case, I think the judge likes to encourage settlements and took it on himself. But I have been involved in cases where magistrate judges have had it, and I've seen them do it very effectively. For example, one time I had a case with Walmart, where a person was injured in the Walmart. And we filed the case in Superior Court in Rhode Island. They removed it to federal court. They wanted it there. So we had it there. And we're negotiating a settlement. This person was pretty seriously injured, but not terribly. And so we were at $110,000. They were at $90,000. And the judge moved us closer. And the judge said, all right, $100,000, that's where this case is settling. I talked to my client agreed. The lawyer for Walmart went out and called the adjuster in Bentonville, Arkansas, and came back in and said, Judge, they won't budge. 90 is it. And so the judge said, okay, they have jets down there. Tell the adjuster, get on the jet, come down tomorrow, explain to me why they don't want to budge from 90 to 100, and I'll accept whatever explanation they have, but I want them here tomorrow. So the attorney went out, called the adjuster back, and lo and behold, came back and said, hey, they're going to pay the 100 and you're going to get the case settled. Just an example of how a magistrate judge has some authority and power to help settle cases. In this particular case, they were so dug in, as you said, I don't think it mattered who the mediator was. The case wasn't going to settle.
If you were Tom Brady's lawyer on that side of the fence and you knew that it really came down to Goodell's hearing the word, just say you're guilty, Tom, and we can make some of this go away, would you do it?
No.
Okay.
No. And in fact, if I were Goodell's lawyer, I would have said to Goodell, get your game suspension. Don't make him admit anything, because there's no need for him to admit anything, because outside of New England everybody thinks he did anything anyway, and just maintain your position and let the case be resolved.
Thanks for presenting both sides of it. That's very good. We hope that you found that this has been interesting, helpful, and gave us an opportunity to broach the idea of how things can be settled or not, what fairness is, what policy is, and that the procedure and the process does matter. I hope you'll continue to stay tuned to The Law Matters, because our discussion of law matters to you.